Thank you, Mayor Gutierrez and council members, for inviting me to be part of this very important conversation. When Mr. Kurtzmarek had invited me to speak, he asked me to identify a couple of problems or some typical problems that we sometimes see with Metro Districts. And I was of the impression that my presentation was to be more of a con. But I want to point out that I have to agree with many of the speakers here that metropolitan districts can be very beneficial. It's just that some districts are more susceptible for abuse than others. And service plans and protections that you build into the service plans and the financial plans can protect against those abuse. So I want to highlight some of the possibilities for abuse here. And as far as I have seen, abuse usually occurs where residents and taxpayers are not in control of the purse strings. And therefore, I want you to think about that, because I think I take a little bit of issue with Mr. Ankheli's statement earlier that developers need to control the districts for an extended period of time. I think that although his firm's a great firm, in fact, his firm is the law firm that represents the Metropolitan District that I'm a director on, and it has been for many years. I think that when developers insist on controlling districts forever, that's where you see some of these abuses. And that's where your approval of the service plan, critical approval of it, is important. Let me introduce myself. I'm an attorney with Berg Simpson Law Firm in Denver, and I'm also a director of Tollgate Crossing Metropolitan District number 2 in Aurora. I've been a director of that district for 11 years. I was also a recipient of the runner-up Distinguished Board Members Special District Association Award in 2012. I'm the general counsel to 2 metropolitan districts right now, and I also represent a number of persons, mostly taxpayers, that have been aggrieved by districts. So therefore, I've seen both sides. I've seen the good and the bad of metro districts. The proper use of metro districts, as I see them, I see 4 purposes, and I think you need to keep these in mind. First, metro districts can finance public infrastructure that otherwise could not be built. So, for example, if you're talking about high-quality infrastructure such as recreational facilities that people want, high-quality infrastructure such as water and sanitation lines that are up to the city's expectations, then it's appropriate. It's also useful to properly allocate the costs in terms of taxes and fees to the users or property owners who benefit. Now that's good because it keeps the mill levies down for the rest of the residents of Loveland that will not necessarily benefit from some of this as much. As Sam Sharp, another fine member of D.A. Davidson that has helped our districts in the past refinance our bonds has pointed out, metro districts can lower the cost of capital through tax-exempt financing. That's an important point, a very valuable point. And finally, and this is something that sometimes is overlooked, metro districts allow local control and participation by residents in a particular neighborhood in governmental decision making. And that's something that's very important, and don't forget about that. Now, as was said before, a special district's a government entity. Here's what it's not, and this is what sometimes gets confusing because developers like to treat it as something not a government entity. It's not a developer kingdom that they can control in perpetuity. It's not a private developer piggy bank that they can simply borrow the money from when they're broke and they need money for additional development. It is not a private homeowner association that is similar to the kind of private homeowner associations you're thinking of. It's a government entity that has much more serious powers than homeowner associations, and it doesn't have the protections for homeowners of the Common Interest Ownership Act that the legislature provided protections for. It's not a source of funding for private civic groups. It's not a means, and this is important, not a means to tax an existing subdivision in order to pay for the developer's next subdivision. You don't want to tax people that already have paid for their infrastructure solely to subsidize the developer in the next subdivision they're putting in. That's not appropriate use. And finally, it's not a source of city funds to avoid Tabor. Now, while there may, and typically what happens is all of the property that is going to be the tax base is put into the taxation district. Maybe it's Metro District number 2. And Metro District number 1 is an undevelopable parcel that the developer keeps control of forever because there can never be any homes built in that parcel. The homeowners, usually the sole reason for this is to allow the developers to continue to control the development in perpetuity so that the homeowners who are being taxed have no control over the use of the funds.
Or said another way, is the board of District Number 1 currently and forever intended to be controlled by the developer that is using these districts to facilitate the construction of infrastructure? Centerra Number 1 currently is owned entirely by the developer, and it has been that way since day one.
What we see is that invites abuse, and homeowners who are taxed should control the operations of their district as well to avoid a conflict of interest. If you allow developers to control the purse strings and you allow them to pay themselves reimbursements without homeowner control of that, it inevitably results in a district operating without accountability. The next abuse that you should be aware of are postage stamp districts. I have to disagree a little bit with the presentation by Mr. Oline, who stated that the smallest district, I believe, had something like 30 units in it. That excludes postage stamp districts, okay? There are a number of districts in Colorado that I have seen as small as 10 feet by 10 feet. Those are developer-controlled districts. They are an undevelopable piece of land, and they are created solely for the purpose of allowing the developers to always own that parcel and always control.
I guess I should say maybe it hasn't changed. Maybe they believe it's been that for 50 years, but none of the rest of us were aware of it. So the focus now, in light of what's called the TAM, Technical Advice Memorandum, is looking at beyond the state law qualification as a political subdivision, beyond or entirely past maybe the use of the proceeds for public purposes. And now we're looking at the question of whether the board of directors of the issuer, in this case District 1, is ultimately accountable to an electorate. It's a concern. It's a concern for the city. It's a 25-year transaction that the city entered into in 2004. I think with the full expectation and belief that District Number 1 would be controlled by the developer at least through that 25-year period. The alternative, from the district's perspective that I see, is we won't have an option. We don't have an option other than this to continue to issue debt on a tax-exempt basis.
Alan, I'm still struggling to get my mind around this, and I certainly don't expect to understand it.
That may not
don't even try.
Service plans and protections that you build into the service plans and the financial plans can protect against those abuse. So